What's up, guys? This is AJ, and today we are going to talk about the high courts in our polity series. Okay, so as I told you earlier, that we are going to discuss polity topics in this series, and what I will tell you this is that see, uh, what is the whatever is important thing about a particular topic. Okay, so these points I will discuss in these videos. Okay, so what your job will be is to revise these videos. Okay, so I know that video quality is not up to the mark, but still see, what is important to clear the prelims is content. Okay, so I am not here to give you a beautiful lecture or lecture which has a various good quality of video and audio. Okay, but I will promise you one thing is that the content will be very good. Okay, so if you want content only, okay, and though you don't focus on the aesthetic values through which I deliver this content, okay, then this lecture series is for you. And in this lecture series we are going to discuss about high courts. Okay, so high courts, like first point says is that Constitution of India provides high courts for each state. Yes, we know that. Then 7th Amendment Act of 1956 authorized Parliament to establish common high courts for two or more states. Okay, see, uh, there are various states and union territories which comes under one high court. Okay, so you must go to the Lakshmikant book and find out the list, and if you can, then you must remember that like which state comes under which high court. Okay, I think one time UPSC asked that question. Okay, then article number 214 and 2331 in the part 6th of the high court deals with the high court. Okay, the constitution's part 6, in which article number 214 and 231 till 231 deals with the high court. Okay, that's not important, just if you can remember, then it's good, otherwise forget it. Okay, the next is a chief justice of high court is appointed by the president in consultation with the chief justice of India and concerned governor. Okay, so this is the point, next point you need to remember. Then next point is like according to third judge cases. Okay, there were three judges cases are in the polity syllabus. Then as per the third judge case, constitution consultation of chief justice of India, it means there will be one chief justice of India plus there will be two senior most judges of Supreme Court. This will term as a consultation. Okay, so at the time of appointing a chief justice of high court, president has to get consult with chief justice of India. Not only the chief justice of India, but he has to consult with other two senior most judges of Supreme Court also. Okay, this is the point you need to remember. This, okay, is a important point. Next point is like what are the qualifications of the high court judge. Okay, so he must be a citizen of India. He must held judicial office for India in India for 10 years, or he can be advocate in high court for 10 years. Okay, these kinds of things are they UPSC don't ask these questions, but it's for our general knowledge, it's important. Okay, then remember these 2 points, these are two most important points. They might ask a question on that. See, there is no age limit given. Okay, but the retirement age is fixed. Okay, 62 years is the retirement age, but appointment age is not fixed. Okay, and you can't appoint a distinguished jurist as a chief justice of high court. Okay, you can appoint him as a judge of high court, but you can't appoint him as a distinguished jurist. Okay, so this is the point. The next is age is 62 years, as I told you earlier. Then question of age will be decided by the president and chief justice of India. Okay, and the decision of the president will be final. The next is a resignation to president. He gives, though he gets appointed by the governor, high court, what is chief justice of India, and president. Okay, but still at the time of resignation he will address to the president. The next is he might get promoted as a Supreme Court judge if there is a vacancy. Then next point is there is a Judges Inquiry Act of 1968. This tells us about the impeachment process of uh, the at the time of impeachment process. We need to appoint a committee to inquire the judges integrity. Okay, so at that time this act help us in that matter. The next is if you want to introduce impeachment, if you want to remove chief justice of high court or any high court judge, okay, we need to introduce impeachment process. For that process you need 100 members in Lok Sabha to present that resolution, as well as you need as well as means or you need or 50 members in Rajya Sabha also can start the process of impeachment of a high court judge. Okay, the next is what, see, understand this process. Okay, first there will be introduction of bill. Okay, the next thing will be like speaker or chairman, whoever is the authority in that particular chamber, he will may admit that request of the members of the parliament, or he may refuse it. Okay, it's a discretionary power in the hands of the chairman or the speaker of the Lok Sabha. Okay, the next point is then what will happen is that the parliament will appoint 3-member committee. In that 3-member will be like first will be the Chief Justice of India, second will be the High Court Chief Justice, the or third will be the distinguished jurist. Okay, so this committee will inquire in the judge's integrity, the behavior of the judge as per the 1956 law that we discussed earlier, and then it will present its report to the president. Okay, the Lok Sabha speaker or the chairman. Then the house will take the voting on that particular bill, and if it get passed, then that motion will be given to the president, and if president signs, okay, if so again, if president can change this decision. Okay, so just remember, unless and until we complete this whole process, there will not be any impeachment of any high court judge or any and the Supreme Court also has the same process. Okay, then next is to give the autonomy to the high court. The expenses of the high courts are charged on the consolidated fund of state. Okay, but the pensions of the high court judges, okay, so remember, just one point is there, it's a crucial point. If you remember, we will not miss any MCQ. See, the salary of the high court judges is charged on the consolidated fund of state, not center, state. Okay, and the pensions of those high courts, okay, judges is charged on the consolidated fund of India. Okay, this is the main difference, you need to remember that. Next point is we cannot discuss the conduct of judges. We also, and the parliament also, cannot discuss the conduct of the judges in the parliament or state legislature. Okay, then we cannot curtail jurisdiction. Okay, but we can change it. Means what? You can't reduce the jurisdiction of a particular high court, but you can increase it. Okay, so that is the meaning of that point. Next is like to prevent the misbehavior of the judges, or prevent the corruption of the judges. We have introduced this condition is that the judges can't practice after their retirement. Okay, they get 50% of their last drawn salary as a pension, and that pension is charged on the state center fund, center consolidated fund, and so we ban them to practice for after retirement. Okay, but see, again, to protect, give them autonomy, okay, to make them independent, we have given the freedom to chief justice of particular high court, that he can't appoint the staff as per his wish. Okay, so this is the thing. The next point is like constitution gives high court jurisdiction over revenue matter. Okay, so constitution has given high court a jurisdiction over revenue matter. This just remember, they might give you this option as an option, this statement as an option in MCQ. The next is one original jurisdiction. See, these are the types of jurisdiction high court has. Okay, there are 7 types of that. See, original jurisdiction, then writ jurisdiction, then appellate jurisdiction, the supervisory jurisdiction, the control over subordinate courts, a court of record and power of judicial review. See, we will discuss these things one by one. Like original jurisdiction means what? The jurisdiction which comes exclusively under the high court. Okay, so if there is a civil matter of a particular state, it comes under exclusively under original jurisdiction of high court. So we can't, as a person, we can't directly approach to the next higher court, that is the Supreme Court. Okay, we have to first go to the concerning high court, then only we can move to the Supreme Court. Okay, so this is the point. Then writ jurisdiction, we know the various types of writs are there. Okay, habeas corpus, mandamus, then citori, then quo warranto. These kind of jurisdictions are there, which we will discuss in the Supreme Court chapter. So these writs are also given to the high courts. Okay, then uh, appellate jurisdiction, supervisory jurisdiction, control over subordinate courts. These terms are self-explanatory, so I don't think so that we need to discuss about that. Then court of record means what? That see, there are 2 points in a court of record. First is that any jurisdiction given by the particular high court can be concerned as a can be used for the next case. Okay, so as a lawyer can use the cases, the jurisdiction given by the high court for another case that in which that case might benefit him. Okay, so this is nothing but the court of record. And as well as what happens is that in the term court of record is that everything is done by the court, is recorded somewhere. Okay, and when a lawyer can use that record. Okay, this is called as a nothing but the court of record. And the second point is that in the court of record there is a contempt of court provision. Like if somebody talks not doesn't talk appropriately about the jurisdiction of the high court, then high court can punish that guy. Okay, so this is nothing but the contempt of court. Okay, you don't need to remember what comes under the contempt of court and what not. Okay, but just need to remember that under court of record these two powers are given. The first is there will be a record of everything said or done by the high court, and next is there will be contempt of court. Okay, then next point is judicial review. Okay, so one more thing I would like to tell you is that Contempt of Court Act 1971 is there. Okay, under that they can punish you in civil or criminal. As there are two types, like civil and criminal. In civil means willful disobedience or breach. Okay, if a person is willfully is not following the orders of the high court, then it comes under the civil contempt of court. And the next is criminal contempt of court, like publication of any matter which scandalizes or lowers the authority or dignity of the high court. It comes under the criminal contempt of court. Okay, as per the Contempt of Court Act 1971. Just remember that. Next thing is I would like to tell you is that, see, we have studied in our freedom struggle that there was a civil disobedience movement. Why it is called as a civil? Okay, that was the point. Civil means willful disobedience or breach. Okay, so that's why it is called as a, in that moment Gandhiji broke the laws, they willfully disobeyed the laws. Okay, that's why it is called as a civil disobedience movement. So next point is let me check. Like judicial review, last point of this high court chapter is judicial review. Say a court can take judicial review of particular thing if it infringes fundamental rights, or if it's outside the jurisdiction of a competent authority, or it repugnant or unacceptable to constitutional provisions. See, any ordinance or any law passed by the center or the state, okay, comes under the judicial review of the high court. High court can judicially review it. Okay, on the basis of three things, like if it is infringing the fundamental rights, or it comes under the outside the jurisdiction of contempt of competent authority, like if state government of Maharashtra passes the laws about something related in the Madhya Pradesh, then it is not possible obviously it is overreaching their judicial powers, or the power given to them by the constitution. They are misusing in that. So it comes under the judicial review of the high court. Okay, so just remember these things, like judicial review. Then if any ordinance or the law passed by the center also comes under the judicial review of the high court. This is my point. You need to remember this point. Okay, it is important point. Okay, so I don't think so is there anything important that I missed in high court chapter. See, one thing I would like to tell you is that high court, as of now, we have just covered the basic points of the high courts. Okay, there are so many cases which are important. Then there are so many decisions given by high courts over the years, okay, which are important or related to the UPSC study. Okay, those things we will cover in upcoming lectures. But right now, as a basic structure of a high court, the basic points of high court that one must cover, okay, these points are covered in this lecture. And so I hope you will like this lecture series. Again, I will tell you one thing is that though the quality of the video is not important, the content that I will give you will be very much beneficial for you. Okay, so and again, to become master in that particular topic, we need to revise that topic again and again. So what I will suggest you is that I'm trying to make these videos very short in length, but without compromising the quality. So if it is possible for you, then you just revise these video again and again, or some after some period of time. Okay, so then it will help you. Okay, so thanks guys for watching this video, and we will meet in the next video. Peace.